To quickly introduce our speakers and the moderator, Ms. Gauri Rasgotra heads CAM's Delhi office. She has advised various multinational companies on contractual disputes and corruption laws. She has vast experience in dealing with issues related to infrastructure projects and arbitration, both domestic and international. Ms. Juhi Chaudhary, Tata Rallis at Tata Enterprise. She is a lawyer with a company secretary qualification for more than 15 years of experience, spread across between law firms and corporates. She has worked at leading corporates such as Mahindra & Mahindra SL Group. In her career, Juhi has handled varieties of assignments involving private equity transactions, debt funding, civil and criminal litigations. Ms. Mayuri Tiwari was a partner at Khaitan and Company. Specializes in international dispute resolution. She has represented clients in international arbitration seated across the world, such as Singapore, London, The Hague, New York, and Mumbai. And she has conducted various different arbitration routes, including investment arbitrations. Mr. Mukund Thakkar is a Senior Vice President Legal, Zydus Group, and is experienced in strategic planning, investments, setting up of companies, corporate commercial litigations, mergers and acquisitions. Prior to joining Zydus, Mr. Thakkar was an Assistant General Counsel and Group General Secretary at Intergroup Technology Quotient and Senior Manager Legal at Bharti Airtel. Lastly, Mr. Unmesh Shukla, Senior Advocate at Gujarat High Court. He is a designated Senior Advocate with rich experience in both arbitrations and related court matters, both at pre-arbitral stage, intermeasures, enforcement and challenge proceedings. Mr. Rasgotra, continue please.
Good afternoon, everyone. I hope I'm audible, and I know that we have only 45 minutes now and everybody is hungry. We'll keep it very short and crisp. So let me start with this, that we have an excellent panel with great experience in the subject to be discussed today. I'll just lay down some of the points regarding the panel and then we will take it ahead. Now, as you all know, arbitration has been an exciting area. There has been a number of judgments recently which have far-reaching impact in the field of arbitration. These are progressive and pro-arbitration. In the time we have, we'll go into some of these developments. We'll divide this topic into 4 parts. The first is party autonomy. As you all know, that Amazon case has Justice Nariman's case, which is very important. So we'll be just quickly going through it and looking at enforcement of Emergency Arbitrators Award. The second is confidentiality. That's the second part, where a new section has been introduced, which is Section 42A, which deals with confidentiality. So we will look at those aspects and challenges. The third is regarding appointment of arbitrators, conflict of interest issues, and challenge to an award. When an award goes to the court, does the court have the power to modify an award, or it can just set aside the award? What is the law? So we'll be just quickly going through all these decisions and aspects. Let me come to my first question, and we know that, and I'm requesting the panelists to keep the discussion very focused, extremely short. First question is to Unmesh and Juhi. If in 2 points you can tell me what are the important principles in the Amazon case, so that we can look at the seat, because in Amazon the seat was Delhi. So we will look at enforcement issues of a foreign seated arbitration in India. So let's start by the principles. Very quickly, if you can, Unmesh and Juhi, just tell me in 2 lines, what is the Supreme Court said in Amazon?
Does it work? I hope I am audible.
Yes, very short. 3 points.
Very short, because I am paying for the whatever earlier has been done, though I was not present. Doesn't matter. But okay, party autonomy rules all the way. The same party autonomy which has seen the concept of seat embedded starting from 2012, so that it overrides section 20 of the CPC. That party autonomy is taken further. And this emergency arbitrator's appointment is a very strong competitor to an interim relief which is granted under section 9. So now you don't have to go to section 9. If you have an institutional arbitration rule in your agreement, then just go to that arbitrator appointed by that institution and get the interim relief. Maybe he is not the same man who will ultimately decide the matter. So that is the big takeaway of Amazon, that till the arbitral tribunal is properly constituted, you don't have to go to court alone under Section 9. You can go to an emergency arbitrator if your rules permit. It was a domestically seated arbitration, Delhi seated, but I believe the same principle should be extended to a foreign seated arbitration. I see no logic in making any distinction. And when the right case comes, I believe Amazon would be followed. Thank you.
Thank you, Unmesh. Now, my question to Juhi. Juhi, what do you think? Unmesh says that the same principles that have been, so just two things, that the same principles that have been laid down in Amazon, which look at party autonomy. Now we are looking at a foreign-seated arbitration. And now, how would an emergency arbitrator's award in a foreign-seated arbitration be enforced in India? Would you like this to be taken by Mayuri? Because I think that was her question. Was I looking at her? Sorry. So it is basically Amazon was a Delhi-seated arbitration and not a foreign-seated arbitration. Can we follow these principles and enforce the emergency arbitrators award? It's a very simple thing. It's not been tested. It's been tested by the court in 2 high court judgments. But let's hear the views. Please go ahead, Mayuri.
Hi everybody, I hope I'm audible. Good to see you all. Thanks for the question, Gauri. Now, let's just very quickly break down the Amazon future dispute. Delhi-seated arbitration, SEAC institutional rules. And the question was whether emergency arbitrator award can be enforced. A very important contention that Mr. Salvi took in this particular case was the Law Commission report actually wanted to include the word emergency order within the definition of arbitral award, and that was rejected. And she sort of tried to buttress that particular point to say that emergency awards are not enforceable. That's when, like Umesh said, the concept of party autonomy came in. And the court very well interpreted Section 2, read with Section 17(1), and said that if a party chooses an arbitral institution, it sort of incorporates the terms of those arbitral institution rules, which includes emergency arbitrator, and therefore, if you've chosen that, emergency arbitrator award will be enforceable. Now, the question that really comes in is, this is a Delhi-seated arbitration. Will this, and that's your question, will this apply to foreign-seated arbitration? Now, you have the Raffles decision in the Delhi High Court, which said that for foreign-seated arbitrations, an emergency award is not enforceable. You will have to file a Section 9, and the court will have to scrutinize the award all on its own. With this particular judgment now, the question arises, can you apply the principle? Interestingly, Justice Nariman, in this particular case, did refer to the Raffles decision, but did not go as far to say that this would apply to foreign-seated arbitration. As an international arbitration specialist, I would love for the answer to be yes. But what we need to keep in mind is the provision in the Proviso 2.2. Proviso 2.2, which talks about Part 1, specifically applies certain provisions to international commercial arbitration, or Part 2. Unfortunately, it does not include Section 17 right there. So, the long story short, in fact, there is a very recent decision of the Delhi High Court where this question did come up in an Indian-Japanese situation, but the court did not go as far to apply it. And even Justice Nariman, in his judgment, said that this principle should apply to a foreign-seated arbitration, but that was more of an observation, it was not the ratio. So I think there is some scope of testing it. I hope, like Umesh said, that we will go by that particular rule, but if you were to technically interpret 2.17 and the proviso to 2.2, there is a scope of argument to say that this would not be applicable to foreign-seated arbitration.
Thank you so much. That was very well answered, Mayuri. In fact, what has happened in the Raffles cases, the Raffles case, the High Court did not apply the amendments of 2015 retrospectively. It did went to Supreme Court. Justice Nariman said you should apply the amendments 2015, but after that there were amendments in the Arbitration Act. So 2015, that judgment maybe is not good law, but like Mayuri said, that for enforcing a foreign-seated emergency arbitrators award, the principle laid down in Amazon's case is very, very helpful. So you can try and get that enforced. So now let me come to my next question for Unmesh. Unmesh, all these institutes like MCIA, they have rules which look at emergency arbitrators award, and it is recognized. Now supposing parties sign to this, then do you think the case becomes even strong?
Oh yes, it would be a great support that parties in the agreement provide for institutional arbitration like MCIA. Personally, I have myself recommended to many people that this is worth trying, because in the rules there is a mechanism for appointment of an emergency arbitrator. You don't have to go to the courts under Section 9, because our experience shows that that is also not easy, because the mindset is still issue notice first. So far as my courts in Ahmedabad I am talking about. So the point is, go to the emergency arbitrator, which is under the MCIA rules, get an order, and then apply Amazon, and there you are straight away under Section 72 for enforcement. So it would be a great help if this can be incorporated. Thank you.
Thank you so much, Unmesh. I think we all agree between Mayuri and Unmesh and me that yes, you can apply the test of Amazon for a foreign-seated emergency arbitrators award. Now coming to the second question, it becomes very relevant on party autonomy. The court has recently said, can two Indian parties have a foreign-seated arbitration? Now, there are two Indian parties who are located in India, go to say Singapore, or they even use MCIA, but they want to do their arbitration in another jurisdiction. And why? Because the challenges there are very quick, very fast. Wherever the award is passed, where the seat is, that's where the challenges happen. So now, keeping this in mind, where court in TASL and GE Power has said Indian parties can choose a foreign-seated arbitration. Now, my question to Juhi is, what are the benefits and drawback of a foreign-seated arbitration for Indian parties?
Thank you, Gauri. So before I answer your question, I'll just quickly give a brief on what this matter was about. There was a settlement agreement between the parties. They provided for a foreign seat, and once the arbitration was invoked, they had GE has actually gone to the arbitrator. There was a award from they had actually chosen Zurich as one of the seats, and when the dispute arose, arbitration was invoked by the ACL. Now GE objected that because this is a dispute between two Indian parties, you cannot choose a foreign seat of arbitration. So the arbitrator did not accept the objections, and they gone ahead and given the award, which was then later on challenged in the Gujarat High Court. Gujarat High Court has stated, they stated that no two Indian parties can have a foreign seat of arbitration, but they said that Section 9 interim relief would not be available. So then the matter went to Supreme Court. The Supreme Court has actually ruled that it is, two Indian parties can choose a foreign seat of arbitrations, and as well as Section interim relief is also available to them. So in the words of Supreme Court itself is that there are, they can have a two bites to the same cherry. So coming to the question which Gauri has asked you, what are the benefits and drawbacks of foreign seated arbitrations? In my experience, I have seen mainly in M&A transactions wherein there are multiple agreements that are entered between the party. For instance, there is a main investment agreement where the investment is coming from a foreign party. They prefer, because they are from jurisdiction outside India, they prefer to have a foreign seat for their arbitration dispute resolutions. But however, when there are ancillary documents, ancillary contracts that are entered with their Indian subsidiary, because there wasn't any clarity whether two Indian parties could have a foreign seated arbitrations earlier, and there have been multiple judgments of the High Court, different judgments of the High Court on this point. We used to tend to have different arbitration clauses for different contracts forming part of the same transaction. So with this judgment, it will be easy and it will be, there will be consistency across the contracts. Now MNC, so this is one benefit I see, and also because MNCs are, because of the long pendencies of the Indian courts, in Indian courts, MNCs are more inclined to have a foreign seated arbitration. So it provides a lot of comfort to them, and also minimum intervention of the court. If, for instance, if it is a Singapore seat that you chose and you go for an appeal under the against the arbitrator award, then in Singapore very limited scope is being provided. So these are all the benefits that I see, which is there when a kind of when Indian parties are allowed to choose a foreign seat. However, drawbacks I would see that when both the parties are Indian, even the assets and everything, the performance of the contract in India, just for the sake of choosing a foreign seat where they would say there is minimum intervention and things like that there, but it's a cost. When the party choose to appeal, there is a cost element involved. So everything is in India, you are going ahead and choosing a foreign seated arbitration. There needs to be some logical reason also behind it, that why would Indian parties will choose a foreign seated arbitration. That somehow I have seen that even in PASL matter also, they had a Zurich seat but they conducted proceedings in India, they chose venue in India. So somehow cost factor were also taken care of. So this could be one possible way, one possible solution, but as in the earlier session and Deepthi was mentioning her experience in the dealers and distributor contracts, it doesn't make sense to have a foreign seated arbitrations when the stakes are not so high. So yeah.
I think we got a very good answer from Juhi, from the fact that she's from a business side. Her perspective is from the business side, which is very well accepted, that yes, for seats and matters where your amount is not so high, it's best to have a seat in India. But ultimately, everybody should keep in mind that wherever the seat is, the challenge to the award is in that jurisdiction. I think before I come to Mukund, Unmesh just wanted to make a couple of things on this.
Thank you. This is the area where I have my reservations, that I am afraid of the next step. And that step is that whether Indian parties will be allowed to choose even the substantive law of the foreign country. The moment this judgment came, allowing two domestic parties to opt for a foreign seat, then immediately the next question, it has already started in the academic circles, I have noted. Why not give the freedom to choose even the foreign laws as substantive laws? And that is where I believe the limit to this party autonomy is required to be imposed and some line drawn. This is the red line. No two Indian parties without any international element can have the freedom to get out of the Indian substantive laws. Simply because those parties are wealthy or rich, they cannot just like choosing a menu in a restaurant, say that okay, now we will not have this, but we will have a Swiss law or a UK law. No, as long as you are in India, within the territory of India, stay bound by the substantive laws of India. Maybe you can get it adjudicated outside, but Indian law has to be applied. Subject to this reservation, and provided this judgment is not stretched beyond this point, I am okay with this. Thank you.
Thank you, Unmesh. And now I would like Mayuri to add. And why I want her to add to this is because it will complete the argument. Because I think she may have another point of view if she is very innovative.
I'm itching to make my point of view to Unmesh's point. No. So, I completely agree to the extent that if two parties do not have any foreign element, then perhaps I agree with Unmesh that there is no reason to choose a substantive law which is outside. But this is a question which is beyond the courts of India. This question goes up to the level of private international law and principles of private international law. And if you want to discuss the principles of private international law which will apply, conflict of laws which applies across jurisdictions, there are just two main concepts which will sort of, and I want to just break it down into two main concepts which will then help determine can you choose a substantive law. And the panel before us actually divided the concepts of lex contractus and lex arbitri quite well. And the two concepts really are express intention and bona fide and legal selection. And this goes back to the MCI rules to some extent. So long as parties have expressly intended to choose a particular law and they have reasons for it, if you go before the court may be willing to consider that particular law so long as it's bona fide and legal. And that concept goes back to the public policy concept. So if it does not violate the public policy of India, it's a bona fide and legal selection, and parties have actually intended and expressly chosen that law. In more the entertainment, the court has actually allowed it. So while I agree with Unmesh that there needs to be a red line drawn, it needs to be really seen what is the center of gravity of the dispute, who are the parties, where is the transaction, and does it make sense for the parties to choose a foreign law? If the answer to all of that is yes, and they make that express selection, absolutely, there is absolutely no bar. But if the answer to that is no, and it's related to marital issues, it's related to criminal issues, it's related to something very specific to legal and policy decisions of India, perhaps there is a restriction. Thank you.
I'm sorry, but please make a response. Sorry guys.
Okay, Unmesh, just 30 seconds because I have to go to Mukund. Very quickly.
Just 30 seconds.
Yes.
The private international law is what animal? It is devised by the Anglo-Saxon smart people to expand their jurisdiction world over. I'm sorry. We must have our own private international law, and we must counter. All legal systems are competing to grab the disputes of the business people. It is Singapore, it is Hong Kong, now probably Dubai, London, New York. Let Mumbai stand in the forefront and let India be the center. What are we talking? We will have our own private international law.
So thank you so much, Mayuri and Unmesh. I think we leave this answer with the audience because we don't have a test case right now for two Indian parties applying the Indian law in a foreign jurisdiction, and both had made their point of view very well. I must now come to Mukund. See, Mukund, COVID actually has been there for 2 years. We have now become absolutely easy without looking at there's any COVID. We are in a room with no masks, right? What do you think, in your view, do virtual proceedings make it easier for parties to refer their disputes to foreign-seated arbitration? Because, we were all online. So do you think, like from your background, you're with Zydus, what do you say?
I absolutely endorse that view, that, if permitted, if possible, you can have a, virtual hearing even for the foreign-seated arbitration. In fact, I recently heard of a case where there was an Indian party and a US party. They had an LCIA as the arbitration. In the entire lockdown, during the last 2 years, they concluded LCIA hearing and the award was passed. All the witness examination, all the evidences were brought online, the virtual hearings took place, and LCI facilitated the whole proceedings. I mean, so long as you keep the fundamentals of online, hearing, virtual hearing, when you are talking about the cyber security, you have to make sure that it's secure. You have to ensure the confidentiality piece. Then you have to also, ensure that there is no witness poaching happening and all of that. Some of them suggested that you can keep a legal representative, at a place nearby where the witness is being examined. The witnesses have been asked to show the video, show the entire room, that they are alone and they are not coached by anybody else. And, so long as the parties agree that the virtual hearing will be, for all practical purposes, be considered in-person hearing, I think it makes a lot of sense. It will also keep the logistics cost to minimum. You can imagine, everybody flying out and, kind of conducting these proceedings in person. And if it can be done in courts, we have done Supreme Court cases and the Delhi High Court cases on virtual hearings. Why can't even the foreign-seated arbitration be?
I think Mukund, I won't allow Unmesh to speak, but the statement is, he made a very important point. Virtual hearings are very cost effective. So while we understand that two foreign parties should not have a foreign law, it will be opposed to public policy. But like Unmesh said, can we actually stretch party autonomy in such a way to even include that? So I think that is debatable. So without going further into it, another question to Mukund. Now this question is that in the Arbitration Act in 2019, Section 42 has come in. Section 42 actually says that confidentiality has to be maintained by arbitrators, arbitral institutes and parties. Now my question is to Mukund, if I have a challenge in court under 34, I'll be disclosing all the documents. Don't you think this section 42A is very restrictive?
It has both the answers.
It has your mandate.
Yeah, so, well, the fact that there is a section specifically provided for this, even for arbitration as well as for conciliation, it is mandatory. But look at it, why it was brought. The committee, the high-level committee that was set up, wanted to make India as a place where, these arbitrations can take place and all that, and there was no formal confidentiality provision in the Act. And therefore, it was thought that let's bring it as a, we always said under Evidence Act client attorney privilege, right? Now, but for arbitration, it wasn't so. And therefore, the confidentiality provision is a welcome provision. It is just that even I was thinking in the same line that while I have the entire proceedings confidential, but when I go to enforce the award, I will have to give out all the details and everything. And now what happens even in the listed companies case, once you get a very big arbitration award or anything, you may have to disclose it under the disclosure guidelines, and there is a set pattern in which you formally disclose all the details of the award. So even these kind of things are there, but I think it is a welcome feature and welcome provision, and it is, so long as it's part of the law, I think it is mandatory.
Okay, I think Mayuri wants to make a point on it, and I would also give this opportunity to Juhi and Unmesh. Very quickly, 2 minutes, tell us how do we deal with a situation where it is restrictive and we are going to make a challenge. Now, when we make a challenge under 34, there may be problems attached to it. There is no problem as far as execution is concerned under 42A. So I would just, after Mayuri, I would also request Juhi and Unmesh to quickly give their ideas on this issue.
I'd like to make a very simple point and take it back to the MCI rules, which is sort of existent in most institutional rules, is the concept of confidentiality. I know there is sort of a dichotomy which is happening here, that you're bringing this provision on confidentiality and then you're going to disclose everything before the courts at the time of execution. But the difference really is that confidentiality will apply to even the concept of existence of proceedings. And when you talk about existence of proceeding, I think it becomes very relevant to our clients and all the stakeholders who use arbitration. They do not want the fact that there is an arbitration that is going on to be known to the public. So that's where confidentiality comes in. Who are going to be the witnesses? What is it that they're going to say? Where are the transcripts? What are the information? What are the regulatory authority points that are made in the arbitration? So yes, while parts of the award, and I have seen situations in my cases where we've made, when you attach the entire part of the award, if there are certain sensitive portions, you can make an application to the court and sort of redact it. But the concept of confidentiality sort of goes beyond that and sort of protects the entire existence of the proceedings. So I think to that extent it's a welcome move.
Could you also speak a little bit about 42A, because these deal with challenges? What do you think?
To answer the first question which you raised, it is an unduly restrictive section. The exceptions to the confidentiality have to be wider. And if legislature has made it restrictive, there is no reason why judiciary should accept it. And judges have many weapons to get out of the legislative problems. Everything which is not prohibited is permitted. So there is no difficulty. We don't have to test their logics. The short question is, what happens if you go in section 9 proceedings? What happens if you invoke section 22? How do you protect the confidentiality? You can't go to the court and say that I want your assistance, but I will not disclose because this is my confidentiality. So 42A section as it is enacted, there is no need to read it literally, and you can invite the courts not to read it literally. Maybe we'll have to wait for some another Justice Nariman to travel to the Supreme Court and maybe the things will settle now, or maybe somebody else will respond to the situation. But 42 as it stands is unduly restrictive and needs to be judicially expanded.
Okay, and what about you, Juhi? What is your reading of this
totally
section?
agree with what Unmesh has said, that as of now, if you see the language of the section, it only covers arbitral tribunal arbitrators and the parties to the agreement. But if you have actually been a witness to the arbitration proceedings, this is not covered as of now in section 42A specifically. And there are other people also who are party to the arbitration agreement. So those people are not getting covered as of now. And as what Unmesh has also Mayuri mentioned, that even the court proceedings, whenever a matter goes to the court, then those proceedings are not specifically covered under the section. The important part here is that parties would like their confidentialities to be, information to be protected. So if they expand the scope of this particular section, it is good. But if in case if they are not expanding and it will take time for the amendment to come in, then the possible solution is that all these institutional arbitration, they do have specific provisions like MCIA and all. They have specific detailed provisions on confidentiality obligations. And in case of court, whenever you are approaching the court, you can request the court to maintain confidentiality, to which I have seen the court usually attend.
I think that's very well answered. I just wanted to make one point here. Section 42A comes from section 75 of the Arbitration Act, like I think Mayuri pointed out. The language is almost the same. But if you see section 34 of the Arbitration Act, 75 can be challenged if there is a breach of confidentiality. Under 42A, there is no such mention in section 34. So with this, I would like to come to a very interesting debate which is ongoing right now in the Supreme Court, is regarding the fee of an arbitrator. Can arbitrator be allowed to make a separate fee for counterclaims? And like Unmesh said, that this, if you are in outside India, probably they will definitely have to follow through this provision. So if tomorrow, if there is also there are conflict of interest provisions in the Arbitration Act, I would like to speak, ask Mukund to deal with this aspect. How do institutional rules like MCIA deal with conflict of interest in appointment of arbitrators? So if you can just give the audience just an idea, and then I'll go to my next question.
So obviously it's a very important part, because when it comes to dispensing justice in the form of arbitration, it is very important that the arbitrator is, there is no conflict of interest with the parties. Now, conflict of interest, while it can have a very simple meaning to understand, but it can have a very crazy connotations about what is conflict, what can constitute conflict, what is not conflict. So obviously there are disclosures that are required to be given by the arbitrators in all these institutional arbitrations, and there are rules regarding this. And once these disclosures are made, they are supposed to be clear of conflict of interest at the time of taking the arbitration, throughout the arbitration proceedings, and once the award is passed, then I understand. So long as the award, challengeability award part is concerned, that if the award is challenged and thereafter the conflict of interest arises, that is not so much so clear in all the institutional arbitration. But till the time award is given, you are supposed to stay clear of conflict, and if there is any conflict of interest which may arise in between, you are supposed to disclose. So that disclosure is very, very sacrosanct for both the parties. Otherwise, the whole award can be challenged on the conflict of interest ground.
Thank you so much, Mukund. I know that Juhi is looking at me. more keen on the lunch very quickly to be served because people have been waiting. I will only limit my third, last actually issue, and before that I would like Mayuri and Juhi, first Juhi, if she can also speak about that Schedule 8 of the Arbitration Act was deleted, and why it was deleted, because a challenge came before the Supreme Court. The government decided to delete it. It did not involve foreign arbitrators as one of the criteria for appointment. I want to ask Juhi very quickly that if 43J were to, the government were to frame rules, what do you think they should have in 43J?
So Gauri, as you mentioned that, under 2019 amendment, they had provided for the section 43J and along with the 8th schedule, which has now been done away with in 2021 judgment, as it seems to be more restrictive. So I think, as of now, the section says that they will provide for the qualifications and accreditation norms and experience of the arbitrator in the regulations. According to me, the regulation should provide that for the arbitrator there shouldn't be any conflict of interest, technical qualifications, and that the arbitrator should be mutually acceptable to both the parties, and also that whatever qualification the parties provide for in the contract should also, the arbitrator should have those qualifications. I'm not in much favor of an arbitrator having a legal qualifications, because we have seen in heard in today's sessions also is that majority of the arbitrators are being found to have come from a legal background, so they come with their own baggage. And I've been my experience and handled arbitrations where a lot of technical dispute had happened. There was an incident, there was a dispute where the parties were disputing on a particular jump plasm of a seat, and it required a lot of experts coming in and giving their views, which for a person coming from a legal background, pure legal background, was very difficult for her to understand. But it is very difficult to find someone having a suitable technical background as well as a legal background. So I would not say that the regulation should make it mandatory that the person should have a legal background. It is good to have, but should not be a must to have. Another point which is there is an accreditation of the arbitrators. Again, I'm not much in favor of this thing, is because I've seen in case of resolution professionals, there was a lot of difficulty that the parties have faced to find a suitable resolution professionals, because it is mandatory to have an RP who have actually qualified to be an RP. Like for instance, there was a need when we were looking for an RP from a real estate background. The pool was limited. Similarly, we were looking for an RP from a steel background. The pool was limited. So the regulation should not make accreditation as a must-have or mandatory, but as good to have, because then, or otherwise, you have a very large pool of arbitrators. So these are the few things that I think the regulation should have.
Thank you, Juhi. And I come to Mayuri very quickly. Mayuri, in 30 seconds, please explain to the audience what is the dispute that is on in ONGC versus AFCON, which the court is hearing, and what do you think? Just 2 lines very quickly, because we are running out of time, and I will have one final question for the panelists and we'll wrap up. Thanks.
I think before I go into ONGC versus AFCON, it's only in India that we're sort of debating challenge to arbitrators, their qualification, whether they should be charging counterclaim fee or not. My view here is there are institutional arbitration institutions. Elect those particular rules. If you see MCI, for instance, there are exhaustive rules on independence and impartiality. There are rules which determine how advance on costs are going to be set. It specifically sets down there will be different advance on costs on claim and counterclaim. When it talks about conflict of interest, which is again ONGC versus AFCONs, under the institutional rules, it specifically sets down what are going to be the challenges to the arbitrator, what are going to be the grounds. And you're going to have a situation where there is going to be a secretariat.
Mayuri, because I don't say what Unmesh is saying is incorrect, of course. But Mayuri, if you can bring some balance on this perspective to see, do you think also it's bad law? How do you think, what should the courts do now in a 34?
Yeah, so I think I agree with Unmesh that this is sort of a little away from reality of how courts work and how arbitrations work in India. And I think the reason why this judgment has come about, and we'll have to look at the history, and very quickly there was a lot of interference by courts. Now suddenly, in their entire pro-arbitration approach, the courts have gone to the extent to say that there cannot be, we can either set it aside, we cannot modify. Now, I agree that that should be the norm, but that should be the norm so long as there is some kind of quality check in terms of the award that is going before the courts. You have a situation here where some of the arbitrators are not trained. There are some gross problems in this particular awards. In those situations, the parties are stuck exactly how Unmesh has said. The solution to this, and I think that's where this judgment becomes relevant. If you have a situation where parties are opting for institutional arbitration, where they're relying on institutions to appoint the right arbitrators with the right experience, having those checks and balances, ensuring, just as Deepthi was mentioning in the previous panel, there is a neutral forum who's sort of being your checks and balance and ensuring that the arbitration is run on time, independence, impartiality is maintained, the quality of arbitrators is good, and you're getting out arbitral awards which are well written, well reasoned, and do not have big flaws in it. I agree with this particular judgment. So to that extent, there is a balanced view that it is sort of away from the Indian reality, but I think we can all aim to reach there.
Thank you very much, Mayuri. Lastly, I would just like to wrap up and say we've had an interesting discussion. Arbitration is actually a growing field. Many issues are still coming up. I think what we've all, and I'll ask some questions if anybody has questions, the panelists feel we need more court judgments that will settle these issues which we have just discussed. So thank you very much. Thank you everyone for your time. And if you would like any questions, we would be very happy to take them. If not, I think everybody is busy with lunch. Yeah, okay. We can close the session, and thank you so much everyone for being here.
Thank you, everyone.
And thank you for your time.
Thank you everyone. We'll now have the lunch and we'll have the next session starting at 2:30.